say, hey, hi guys, I'm Bob Carr. I'm the CEO founder of Link SV. Dawn's also with me. She's my partner in Link SV. And we love the idea of hosting an event with Roger because at Link SV, we capture all of the capital raise, corporate capital, angel capital, venture capital, private equity. And we've tracked key people at M&A, all that sort of thing. And in doing so, we have a lot of good friends in Silicon Valley who have a lot of expertise. And so we like to get someone like Roger to come share with us. There's so many things in the legal community that impact small companies. It makes it all very valuable. And so we started doing this. Are we on our third one now, Roger, I think?
This is number 3.
Number 3. And so Roger brings great information to make us all smarter. Today's category is something I'm kind of blind about. It has to do with employment issues. So and for startup companies, even if you were just getting started. So it's very valuable. So Roger, great to have you. I've known you for 30 years. I've respected you for all those years and have enjoyed working with you. And I'm so happy that we're doing this session together.
Okay, thanks, Bob. And as Bob mentioned, this is the third in a series, Legal Strategies for Startup Success. We've had formation, we've had capitalization. This week, we're going to talk about employment law issues for startups. It might be the number one biggest problem, headache, areas of non-compliance for a startup company, especially if you're in California. It may be the number one legal issue that tanks startups when it takes them and becomes just a big headache even when you get it right. So, and this is a survey course, and we want to just make you aware of what the legal issues are so you know enough to ask your lawyer about them. Before we get started, just a couple of things. This is being recorded. This will be public. I will send you a link to the recording, and the prior recordings are also available. I'll send you the slides if you want them. I also post the slides on SlideShare. In fact, these might already be there, although I made some changes to them about an hour ago. So I'll send the updated ones. I'm a lawyer. I can't help myself. Every time I look at something, I got to change it. So with that, again, I'm Roger Royce. I'm a partner with Haynes Boone in Palo Alto. I do emerging growth and venture capital. And I am going to start the share. And now I'm going to start the slide share mode, and you should see one screen or one slide. Is that what you see?
Yes, one slide.
All right, that legal strategies for startup success, session 3, employment law issues. Do you see a slide that says summary?
We are on summary, Roger.
Oh, great. Success. All right. Thanks very much. Okay. With that, I'm going to mute everybody but me, and we'll get going. What we're going to talk about today is a summary, like I say, of labor law or employment law issues that are of particular interest to startup companies. And these are the things that really you just got to get right. And some of this is very counterintuitive. There's a lot of lore out there that runs contrary to the law. So we're just going to walk through what the law says, maybe even what startups actually do, and how we sometimes bridge that gap. We'll talk about the number one issue, which is misclassification, or more accurately, misclassification. In other words, you call somebody an independent contractor when the law calls them an employee, and all the trouble you can get into over that. Secondly, wage and hour laws. If you're in California, then you already know that there's hardly anything as Byzantine as our wage and hour laws. In fact, I've often said that I've never met a company in California that is in actual strict compliance with our wage and hour laws. It's very difficult. I want to talk a little bit about work product, who owns what the employee or the contractor for that matter creates, and how do we make sure that that work product ends up in the right place. Talk about non-competes, non-solicits, some activity going on, the confidential information agreement and invention assignment, also known as the CIAIA. California, again, this fairly recent concept of wage theft that you need to know about if you're a startup. And then hopefully we'll spend some time on equity comp and maybe even a little bit of immigration. So so not in that order though. I'm going to start with work product because this tends to be sort of the number one issue or the first issue that comes up when we form a company hires its first employee. And the issue is, and we'll talk more about this next month when we get into IP, but who owns the stuff that the employee creates? Because clearly we want the startup company to own it, not the employee, because employees will leave your company. And the typically when an employee leaves, they walk out your IP walks out the door if you don't have the right agreements in place. So you should be seeing a slide that says ownership of employee work product. Is that the slide you see, Don? Is that the slide you see?
Yes, it is.
Okay, good. Check. I did a whole presentation once on slide number 1, so I'm careful. We'll talk about other provisions, work for hire, that actually allows you, well, we'll talk about what that is, the labor code, and then shop rights. Okay, let's jump right into it. So the first thing that'll happen when you hire an employee, if you are an employee, you have no doubt signed a confidential information agreement and invention assignment. If you're a startup company, you will want all of your employees and any other service provider, for that matter, who's touching your IP anyway, to sign an agreement that says a couple of things. Number one, that the company owns what it is that they're developing. Now you'll notice this yellow highlighted portion, because we have a case, believe it or not, where there was an invention assignment that did not have this language. It had everything but this language, but it didn't have the language that says, I hereby assign to the company. And a court ruled in that case, well, you might have intended for the company to own everything the employee did, but it doesn't say that they've assigned everything they've done, and therefore they didn't. So to be careful, super careful now, we want to make sure that I hereby assign to the company language is in our documents. And this is the first example of a theme that I'm going to harp on, is that it is so easy these days to go ask AI to draft an agreement for you, or to go online and find one, or to just copycat somebody else's agreement. And words matter, and these little words matter a lot. And in that particular case that I'm referring to, it mattered enough where the company ended up not having the IP. And the way it came up in that context is they tried to sell the IP that the court said, you don't own it. You never got an assignment from your employee. So that's number one. We want to make sure that our assignment actually does assign. But now there's another subtlety here. You look at the words in the brackets, and sometimes if you'll see an agreement, an assignment agreement, where it basically says that the employee is going to assign everything they create during their employment, the relationship, during their employment with the company, everything they create, they automatically assign to the company. And that's not really what you're trying to do here. What you're trying to do is add the words in a bracket. It's whatever they create that relates to the company. And in fact, this labor code section we're going to talk about says that if somebody does a little bit of sloppy drafting, or they make a mistake, or maybe they're just even being nefarious and they are trying to get everything they create on nights and weekends, at least here in California, our labor code will fix that problem. But I'd rather not rely on the law and a court to interpret it. I'd rather put the language right in the agreement and say, look, what we're talking about is everything you do for the employer. All of that work belongs to the company. And if you paint paintings on weekends, that belongs to you. Okay. Or write music, or, scripts.
Hey, Roger.
Yes.
We can see the slides, but I didn't notice that they're not in presentation mode. So if you go up and do slideshow, I think it puts them in presentation mode.
How's that? Is that different?
No. Go up above to your to slideshow on the on the navigation bar.
Sure.
Try that.
Nope.
No difference.
Okay.
Okay. One of the audience is pointing out we're not in presentation mode, and I'm trying to figure out where that is.
Yeah, that's what I was hoping we would do.
And Roger, I have a quick question when you have a second.
All right, this is in presentation mode now.
Mm,
California Labor Code, it says, Roger.
Do you see, is it in presentation mode?
he's saying no.
Okay, hold on. We're gonna get this right. We're gonna get this right if it
Can
kills
you
me.
hear me, Don?
Yes, I can hear you.
Oh, I want to ask Roger a question.
Yeah,
Well, let's hold questions to
there,
the end.
there you go. There you go. You've got it, Roger.
Okay,
All right.
we'll hold questions. till the
Okay,
end.
let me continue then. Okay, so the other thing to notice about this super important document, the confidential information agreement and invention assignment, is that they'll always say that the employee is assigning everything they create, except for the stuff on the schedule. And there'll be a schedule of prior inventions. And that schedule is really super important. And a lot of times people just ignore that. And whether you're the employee or the company, I'd advise you not to ignore it. If you're the employee in this relationship, well, you want to make sure you carve out what it is that belongs to you and does not belong to the company. And the best way to do that is by scheduling it on Exhibit A. And if you're the company, you would like to, a future judge to know that everybody has taken this agreement super seriously by completing it. And if you don't complete the Schedule A, I can see a clever litigator saying, look, the parties never finished this agreement. We have to go in and reform it. So I think pay attention to that, even though a lot of people tend to ignore the schedules. All right, so I mentioned our statutory limitations. And I'd like to talk about California Labor Code Section 2870, because here in California, this is really important to know, is that we have, let me just show you the statute, and then I'll tell you, this is the statute itself. And it basically says that an employment agreement really can only assign so much. In other words, the statute basically says you can't get everything the employee has. You have to have some carve-outs. And let me tell you what those carve-outs are. So if it's created on the employee's time, didn't use the employer facilities, doesn't result from work performed for the employer, and most importantly, is not related to the employer's business, then that, regardless of what your CIA says, your invention assignment says, that IP belongs to the employee. And basically, the statute says that if you have a provision in an employment agreement that says anything else, that provision is unenforceable. And this is something that's very common in California, where the statute will just come in and tell you what you can and cannot agree on. We'll see that later with non-competes. So something to keep in mind, what we typically do is we always just put that right in the confidential information agreement, because we don't want to risk a court saying the entire agreement's unenforceable. So we just go ahead and comply with it. Now, I want to pause on this for a second, because it's pretty easy to know if you've done something on the employee's time or the employer's time, right? If you're a 9-to-5 employee, okay, you know what's your time and what's the employer's time. Pretty easy to know if you've used the company's computer or their lab or whatever. Where we run into difficulty is this part about, is it related to the employer's business? And that's a factual issue, and that's the one that gets us in trouble. Now, I know a lot of you entrepreneurs, you might have a full-time job and a part-time startup. And this is going to be super important to you, because you no doubt have signed an invention assignment. It no doubt has these carve-outs if you're in California. So you want to make sure that what you're doing not only is on your time with your facilities, your computer, your lab, your office, whatever, but also that what you're doing is not so closely related to your employer's business that after you leave and launch your startup, you're not going to get a letter from your employer, a cease and desist saying, hey, that belongs to me. You made that for me. So this is a very important statute to really become familiar with, at least here in California. And then a couple of other things I want to mention. You don't hear much about this too much, but it's worth pausing on as we're talking about who owns the IP that the employee creates. You'll see this clause in a lot of agreements. I acknowledge that all company inventions are works made for hire. Well, what is a work for hire? It's a copyright concept, and it basically says that the employer, not the employee, is the author of a copyright and the owner of the work as long as it's created within the scope of their job. Now, the reason I'm pausing on this, because it doesn't seem to add much to to this broad assignment language, is that you see that just kind of, dropped into all these agreements. Sometimes it gets dropped into an agreement with a non-employee, an independent contractor. Well, oddly, and I don't know why, I don't know the history of this, but oddly, California law says it has this concept of statutory employees, people who are employees just because California says so. And the statute says that an employee includes anybody who agrees to a work for hire clause. Now, there are some hacks for that if you make that mistake and if you get around it. But if you just read the statute, it says if someone agrees that what they do is work for hire, well, now they're an employee. And we're going to talk about what that means in a minute, but you can imagine it's withholding, it's minimum wage, it's unemployment insurance, it's et cetera. So I try to be careful, not to have work for hire language in documents that don't relate to employees. I will tell you the market is not so careful. I see that in almost every agreement, whether it's an employee or not. Second thing I want to mention before we move on from this topic is this concept of shop rights. So what happens if the employee doesn't sign a CA? It happens once in a while. Sometimes we just forget or they don't sign it or they don't return it or whatever, and then they leave. Well, the employer probably has a shop right, but that's really a non-exclusive license. And it's judicially created, and it's not as good as having a document. And it does not establish ownership in the employer, just gives that employer a right to use what the employee has created. So at least the employer is not out of business when the employee leaves. But when they go to the VC and they have to make that representation about ownership, they're going to have some problems. Let's talk about some other covenants that you'll see employees agree to when they start, because this is where it kind of really gets juicy now. So confidentiality, absolutely. Employee has to keep, any confidential information as defined of the employer a secret. So the important thing to note is there's standard carve-outs. And sometimes people forget about these carve-outs, but there are important carve-outs. Number one, agents with a need to know. If the employee needs to tell his lawyer what it is that he signed, you wouldn't want to have a covenant that says he can't do that. I have seen that happen, by the way. Another exclusion, if a court orders them, well, and then obviously, and sometimes you'll see a lot of language around that says, well, yes, but you have to give me, the employer, notice of that first and give us a chance to challenge it, etc. The most common one is a carve out for information that's just publicly known or made known, and it wasn't the employee's fault that did that. That's another carve out to confidential information, and that should be in every one of these agreements. And then more recently, we have a Federal Defend Trade Secrets Act that I'll talk about in a minute, or actually I'm going to talk about that next month. But basically, it's the whistleblower immunity. You'll see that carve out in newer confidentiality agreements that says there's nothing in here that would restrict you from being a whistleblower and turning a company in if it's violating laws. Another important clause in these agreements, and if you're an employer, if you're bringing somebody on, if they bring with them confidential information or inventions that belong to a prior employer, that becomes your problem if you hire them. And you don't want that to be your problem. So you'll have them sign an agreement where they promise that they're not breaching any other agreement by going to work for you. And they're not bringing any confidential information with them or any inventions or anything like that to the new company. And that way, when you get that letter from prior employer that says, you've hired our employee, we want to remind you that they've signed agreements with us and we're going to be keeping an eye on you and we will enforce them, you can respond that, yeah, we would never dream of using your confidential information. In fact, we made the employee promise that he didn't bring any of it with him. And that's the right way that this should all play out. Okay, now let's get into some of the thornier stuff. Non-solicitation, you'll see that pop up in almost all confidential information agreements now, or at least in most of them these days. And there's a couple components to it. And this is really legally interesting, actually. So first of all, a non-hire is not the same as a non-solicit. A non-solicit means that the employee, after they leave the employment, they're not going to go back and, and start soliciting all their buddies at their prior employer to come with them. That's a non-solicit. They're promising not to do that. They're not going back and saying, hey, I got a much better deal at this new employer. I think I can get you on. Why don't you quit your old job and come work with me? That's a non-solicit. A no hire is much different, right? A no hire is a promise by the new employer that they won't hire, or promise by the employee that they won't hire somebody. Well, what's the difference? Well, the difference is that when you leave your company and start your startup, and you'll post an ad of general application that says, hey, we're a startup and we're hiring, and somebody from your old job sees that, that's not a solicitation. But so you wouldn't violate your non-solicitation because it's not specific. But if you had a no hire, you would violate that. But a no hire, at least in California, is generally not viewed as enforceable. I'm going to talk more about that later. So that's the non-solicit. The second part of this is the no hire part, you'll see. And that doesn't mean you can't do anything to stop employees from moving on. And the usual way we deal with this is we say, we make the employee promise that they're not going to use any confidential information of the company in order to not only employees, but clients, customers. Now, why do we have that bolded clause, I shall not use any confidential information? Because if we didn't, what we would have is an invalid non-compete, right? So you can protect your confidential information. We got specs, we know how much somebody gets paid. We know what the customers usually order. We know how to reach the customer. We know who the person is at the customer, that makes a buying decision. That all might be confidential information. So we can restrict that use, but you couldn't restrict somebody from going across the street and then competing with you, at least not in California. Some states you can, but not in this state. So let's talk about the California limitations, because this is all very state specific. There is federal law around this, and I'm going to talk about that. But first, I want to pause on the state part. And the state laws can vary widely. California is probably the most protective of employees. And that's probably one of the things that built the Silicon Valley, is our policy that favors employee mobility, making it very easy for employees to go from one company to another company without a lot of restrictions. Other states take a different approach. Minnesota, Texas, New York come to mind, where it's a little bit more employer favorable. So let's talk about the California rules, since that's where I primarily practice. So our statute, Business and Professions Code, makes void basically every non-compete. That's what that is. Non-competes are void. And it defines them further by, well, you can see the language. Basically, you really difficult to restrict somebody in working in their chosen profession or field. So that would be a non-compete. But you know what? Sometimes it can even apply to a non-solicit. And so I cite the case down there that tells you the difference between a no hire and a no solicit. But let me tell you how it applies more broadly than to just non-competes. But before I do that, I do want to mention that even California law has exceptions. We have exceptions for agreements designed to protect trade secrets. Remember that language I had? You won't use our confidential information to compete with me. That's okay. Agreements, and the biggest one is agreements in connection with the sale of the goodwill of a business. In other words, when you sell your company, you're an employee of the company, you'll sign an employment agreement with the buying company. That employment agreement will have a non-compete. If that's sufficiently tied to the sale of your old business, a court, even in California, will enforce that under this exception, because the buyer is buying the goodwill, and the goodwill pretty much depends on you not competing. So, interesting case a few years ago, where we had a California court that looked at an employee non-solicitation agreement, which we all thought was totally enforceable in California. It's not a non-compete. And you said, you know what? This is unenforceable under our non-compete statute. Well, how could a non-solicit be unenforceable under that statute? Well, read carefully. Look at number 2. restrict an employee's right to number 3, violate an employee's right to work in a particular profession or field. Well, in this case, the profession was recruiters. So to prevent them from soliciting would basically be a restriction on their ability to work in their chosen profession. So when that case first came out, there were a lot of lawyers that said, that's it, non-solicits are no longer enforceable in California. We're not even going to try. Since then, I think the market has come around to saying, yeah, maybe. We just have to look factually on what it is, what the profession is that the non-solicit is popping up in. I can tell you these are still in California confidential information agreements. It's standard language, so I don't think it's gone away. But I would say that sometimes there may be some doubt on the enforceability. Non-competes. This is pretty clear. Like I said, California law prohibits non-competes in an employment context. And so other states have a different rule. They have what we call a blue pencil rule. In other words, a non-compete's enforceable as long as it's reasonable. And if you draft a super broad non-compete and it's, you can't do anything that we ever think we might want to do any place in the universe, a court, instead of just declaring it invalid, would blue pencil it. They'd say they would, basically cut it back to something that's more reasonable. You can't be engaged in this particular business in this particular geography. See, California, we don't get into any of that because other than in connection with the sale of a business, a non-compete in an employment contract is simply unenforceable. And it has gotten way worse in this state over the last year. And I will tell you why, because I spent my career talking to lawyers from other states who just can't believe this California rule. And so they put the non-competes in the agreements anyway, saying, well, those employees, they don't know any better. This might chill them from competing. Our legislature caught on to that. And most recently, it is now unlawful to even include or try to enforce such a clause in an agreement. And there was case law to that effect prior to the statute, but now there's a statute that basically says that's an unfair competition. And not only that, you could end up paying penalties if you even try to enforce such a clause, unenforceable clause. Now, I want to mention the federal rule because this is really sort of interesting. It was a little more than a year ago that our Federal Trade Commission decided, we kind of like that California rule. We think that should be the rule across the entire country, even in Texas, Minnesota, and New York. And it issued a final rule in April that banned non-competes nationwide. They had some exceptions, just like California, sale of a business, for example. In August of last year, a federal court, I'll give you 3 guesses which state that court was located in, issued a decision basically stopping the FTC from enforcing the rule. The FTC said, yeah, well, we disagree. We think we still have the right. So we got this fight, and we had this tremendous uncertainty for a while as to whether there was a federal law banning non-competes. But in March of this year, the FTC, under a new presidential administration, it takes a different view than the last one on virtually every subject, and as well as a new chair of the FTC, has said, we're not going to address any challenges to this non-compete rule. And in effect, they're probably going to reconsider, and we don't see the FTC enforcing this non-compete rule. All right. And so who knows how that's going to end up, by the way. But for now, I would say that we're not super duper concerned about a federal non-compete. If you're in California, it doesn't matter. But if you're in other states, it does. Okay, let's move on to the number one biggest issue for a startup when it comes to employment. At least I think it is. And that's worker classification. And so the real issue here is that if you're a startup company, I can't tell, I have this conversation with almost every company. It comes up over and over and over again. You're doing your math and you're saying, if I hire this guy and make him a contractor, I don't have to withhold taxes. I don't have to pay payroll taxes. I don't have to give him health insurance. I don't have to worry about wage and hour laws. I don't have to give him benefits. I don't have to give him workers' comp. You know what? I think it's an independent contractor. So businesses very much prefer that. In fact, by some estimates, it's a 30% cost difference, right? Instead of $100, it's $130. So it's a big, big number. But so you can see there's a huge incentive for businesses to classify their workers as contractors and not employees. Well, if you do that, and if you get it wrong, you have three constituencies to worry about. One is the employee or misclassified worker themselves. Secondly, it's the state taxing authorities and workers' comp and unemployment comp. And thirdly, it is the Internal Revenue Service. And let's just talk a little bit about that. So here's the law of employment status. So the IRS has a control test, and it's a fuzzy factual test based on whether the employer has control over the employee. And if there's sufficient control, and I'll talk more detail later, but if there's sufficient, for now, if there's sufficient control, well, then that person is an employee, right? The California rule is a little bit different. In fact, it's much different. In fact, it's so different that a person could be sitting in Tahoe City, California, and be an employee and cross that line over into Incline Village, Nevada, and all of a sudden they're no longer an employee. It's that different. In California, the presumption is that a worker is an employee, meaning that the employer has to disprove that presumption. And the way you defeat the presumption is by meeting all of the following three tests. It's called the ABC test, and it is now, as you probably know, part of our statutory law. One, the worker is free from the control and direction of the hiring agency. Well, that sounds very much like the federal rule, right? So hopefully that's usually pretty clear. We know whether we're controlling that employee or not, right? You go to hire a lawyer, you're getting a product. You're not, making them punch a time clock and making sure they show up at work every day and directing them as to how to get to that product. So pretty clear. Let me skip to the third one. They're independently established in an independently established trade, occupation, or business. While that's a little tougher, that generally means they're holding themselves out to the public as doing this job. But it's the middle one that really gets them in California. The worker performs work outside the usual course of the hiring entity's business. So let me kind of express it the way it was explained to me by someone from our California's Employment EDD, Employment Development Division, which enforces these rules in California. The example is, let's say you're a lawyer and you need someone to cover a deposition for you. So you hire another lawyer from another firm to cover that deposition. Under this rule, that person who shows up for 2 hours to cover your deposition for you is your employee. Now, that's, if we read no further into the statute, that would be the law. That is not the law, however, for lawyers in California, because lawyers have a really good lobby. And we have an exception to this ABC test for lawyers. And there's an exception for attorneys. In fact, there's about 100 exceptions in this statute. And you really have to wonder, about the efficacy of a rule that has to have 100 exceptions. But that's what we have in California. And if you've got a good enough lobby and if you've got an exception, you're not going to be covered by ABC. But if you're not with an exception, you are. Well, if you're not covered by ABC, what are you covered by? And that's the old, what they call the Borrella test. It's a common law test, meaning it's derived by courts, which basically looks to the control or the right to control of the manner and means of the work and the worker, the multi-factor test, which is very, very similar to the federal test. And the last thing I want to say about the California rule here, other than it treats, it's very, very broad, very, very broad, unless you're within an exception. But the other thing is that we have a concept here beyond that called statutory employees, right? And I already gave you, one statutory employee, that's a work for hire person. Another one is officers. In California, if you're an officer, you're automatically an employee. And that does create a little bit of concern because now we have outsourced, we have officers as a service in effect. And you have to wonder, is an outsourced CFO an employee? The answer is usually not, because although they have that title, they're not actually selected by the board to have the duties of an officer. So that's, that's how we bridge the gap. It's just nomenclature. But keep in mind, California is very expansive on this. The federal rule, I won't spend a lot of time on this, but a year or so ago, the Department of Labor, under a different administration, decided to tighten up on this rule, and they gave us these 6 factors that would determine whether someone's a contractor or employee. Well, as of May of this year, and I'm recording this in June of 2025, but as of May of June 2025, our Department of Labor said, yeah, never mind, we're not going to enforce that 6-factor test. So DOL is currently reviewing and developing a revised standard. We'll see if we actually get one or if this is something that's just going to be left to the states. Now, what happens if we get this wrong? Okay, I've convinced you that, that there is such a thing as misclassification. What's the big deal, you might say? Oh, you don't know. Let me tell you. First of all, unpaid tax withholding. So not only the payroll tax portion, so the employer has an employer's portion of payroll tax that they pay, but employers also have to withhold income tax and Social Security or payroll taxes from the employee's pay. And if they're misclassified in their contractor, they haven't done that. So they now are primarily responsible for those taxes. Now, here in California, you get an exception if you can prove that the employee actually paid those taxes. But then there's a penalty on top of that, and you don't ever get abatement of that penalty, except in very narrow specific circumstances. So what I'm trying to say is that if you do mess this up as an employer, you can plan on paying your employees' taxes. Let me put it that way. That's how it tends to end up. Plus penalties, plus interest, by the way. And that includes Social Security. It includes unemployment insurance, workers' compensation. So those are the tax aspects of this. On top of that, employees are entitled, unless they're exempt, they're entitled to overtime, they're entitled to minimum wage, they're entitled to meal breaks and lunch breaks, they're entitled to sick pay sometimes, work-related expenses. And if their wages aren't paid, in California, we have this thing called waiting time penalties, which is up to a month. In other words, they get their salary for a month while they wait for you to pay them in full. And to add insult to injury, there are also penalties that could apply. And there's also I'm going to get to this later, but a fee shifting statute that requires you to pay their attorney's fees. Now, I want to pause on a couple of things here that I've highlighted, because if this doesn't scare you enough, this ought to. Number one, if it turns out that what you've done is a willful misclassification, in other words, you just misunderstood, or you had a good argument, or you didn't know what you're doing, if it's willful, now you've got penalties. And those penalties, as you can see, are quite high, right? Up to $25,000 per violation. Secondly, and this is a fairly recent development in California, or let's say a recent expansion of California law, is joint and several liability, meaning that the people working for the employer who knowingly advise on a misclassification could be personally liable. Now, when this law first came along, pretty much every lawyer in California freaked out, saying, wait a minute, I could be liable for penalties if I advise an employer and they get it wrong. But there's an exception for practicing attorneys now. But otherwise, people who participate in misclassification have huge potential liability here in California. I want to drill down on a couple of things. One, I mentioned the attorney fee shifting statute. Let me tell you how significant this is. There is a case a few years ago. It was a law firm, an out-of-state law firm, that misclassified one of their employees. They had a dispute. The amount in dispute was tiny. It was maybe a couple $1,000s, but they're a big, scary law firm, and they're not afraid of any employee, and they fight everything. So they fought everything. they ended up paying tens of thousands of dollars of attorney's fees on top of, the $2,000 of wages that they forgot to pay. The attorney fee shifting statute is very significant, right? If you get it wrong by $1, you could end up paying an unlimited amount of attorney's fees, proving that. And that kind of shifts the burden to employers to be super conservative about this. And sometimes, it's easier just to give up on an issue than to take the risk of fighting over it. But it gets worse. There are potential criminal penalties. And I want to pause on this because this is one of those few areas where a startup can actually get into criminal trouble. Criminal trouble, what does that mean? That means you could go to jail. Yes, jail. And workers' comp is the one example I like to use because workers' comp statutes in California have criminal penalties for knowingly and intentionally violating these rules. Or willfully, I should say. Penalties we talked about. And then finally, the last thing, I don't want to scare you to death, but I will leave the scariest for last. We have something here in California called private attorney general claims, PAGA claims. And that means that any employee can sue on behalf of any other aggrieved individual. And they're what they call a stand-in for the attorney general. So they're suing on behalf of everybody else who's similarly situated. So one employee might say, okay, look, you owe me $1,000, that you should have paid me for my lunch breaks or whatever. Hardly worth the trouble. On the other hand, if you have to pay my attorney's fees for suing you, plus I can sue you on behalf of everybody else that you misclassified, well, now it becomes a real profit center for that employee. And PAGA is an area that's under development. It's recently amended. I'm going to do a whole podcast on PAGA eventually, but it is one of the scarier things in California. And I have seen companies, more than one, put out of business because of PAGA claims. So it's something to keep in mind. It's real. Okay, let's talk about wage and hour now. Let's say I've convinced you need to hire people as employees and not contractors. So now what do you need to pay them? Well, there is a federal minimum wage that we all probably know about, and there are federal wage and hour rules. And to avoid having to pay minimum wage federally, they have to be an executive employee. That's the exemption we typically rely on. And that requires an amount that goes up every year of minimum salary that they receive, plus their primary duties have to be management, right? So you pay executives. Executives are exempt from wage and hour laws. They don't have to get minimum wage, and they can work nights and weekends, etc. They don't have to be paid overtime, but you have to meet all of these tests. A lot of people, you can't just call someone an executive and avoid these rules. They actually have to meet these tests. They have to be management. And it's, other than this compensation test, the rest of it's a little bit fuzzy. It's facts and circumstances. As you might expect, California has its own parallel wage and hour laws. We have a statewide minimum, which last time I checked was $16.50, might have gone up since then. But then cities and counties can have higher minimums. And actually, there are higher minimums for certain types of industries and exemptions. Overtime pay is specified by statute. We have standard overtime and double overtime. And again, we have an exempt employee concept in California as well. It also depends on how much a person receives, but also that they're managerial. If somebody is not exempt, they have to get minimum wage, they have to get overtime, they have to get unpaid meal breaks, they have to get paid rest breaks and sick leave. So it's a nightmare of record keeping and management and administration. And that's why I say it's rare that I see a California company that actually complies with these rules, unless they have a dedicated HR department that's keeping an eye on it. And, if you look at my website, I've got entire webinars on this topic. For example, what happens if somebody checks an email while they're at home? I mean, do they get overtime for that? Things like that. So just keep in mind that these wage and hour laws are pretty Byzantine. Now, I know what you're thinking. Well, how about the founders? I'm a founder, so I shouldn't have to, first of all, I'm not going to sue my own company. And I've heard that there's a founder's exemption. Yes, under federal law, there is a partner exemption, I guess you would call that, for founders who own at least 20% of the business and manage it. So those persons can qualify for this executive exemption. So we don't, my God, if founders had to get double time and overtime, there'd be nothing left for the company, right? Because everybody works so hard when you're starting a company. So there is a federal exemption. But remember, I said it's a federal and state wage and hour law, and California does not recognize that exemption. So for California purposes, even founders have to be paid minimum wage, and that has to be paid in cash, not just equity. And I know what you're thinking, nobody does that. And I get that. And the theory is that what, the founder's going to sue their own company? Probably not. But there will come a point when you do have other constituents and where the founder may sue their own company. And I've seen founders sue their own company for wage and hour many times. Once you get to having other constituents that are going to pay, like investors. Now, I want to pause on a concept, again, in California known as wage theft, which is broader than it sounds. It basically means not paying somebody wages they're entitled to, maybe because you misclassified them, or maybe because you didn't pay them overtime, or they didn't make minimum wage, or they didn't get a meal or rest break, or most commonly, they terminated their employment and you didn't pay them fast enough. So this is pretty scary stuff because there are potential penalties and fines, and there's also potential personal liability for this concept of wage theft. Now, what do I mean by personal liability? That means that the individuals who participate in this, owners, directors, officers, managers who cause or contribute to wage violations, may be held personally liable. So it's not automatic, a court has to make this determination, but that is a scary thing because that could be a big number and it is personal liability. Remember in our first session, we said we form a corporation to isolate the owners from the liabilities of the business. So if the business fails, at least the owners don't go down with it. Well, there are exceptions to that corporate shield, liability shield, and this is one of them. And that even extends to waiting time penalties. Remember, that's at up to 30 days of daily wage that someone gets while they're waiting to be paid up. So these can be big numbers pretty quickly. I want to hit, in the time I've got left, the final payment rules. Just briefly, when an employee quits, they got to get their final paycheck within 72 hours. If they're fired, they have to get it more quickly than that. So just keep in mind, if that final wages are not paid on time, then the waiting time penalties start. Also, when somebody leaves, we oftentimes put in place severance agreements. And if we don't have a severance agreement, they walk away with whatever claims they have against the employer. Or most employers are going to say, look, we'll pay you 2 weeks worth of severance pay, but in exchange, you'll sign this agreement and it'll have a bunch of releases in it. So I know you're not going to sue me for all the things that California and federal law allow you to do. Well, be careful because this, again, is another area where you just don't go online and copycat somebody's agreement from Texas because it might look a lot different. And first of all, there's the federal rules. And I've highlighted kind of the important provision under our Older Worker Age Discrimination Employment Act. And an older worker, by the way, is defined as someone over 40, which doesn't seem very old at all to guys like me and Bob. But for purposes of federal law, those are the people that are deserving of protection, meaning they get 21 days to review an agreement and 7 days to revoke it after signing. Why is that significant? Because what happens if you pay somebody their severance before that 7 days is up and then they revoke it? Oops. And they have to have some other advisements that are set forth in the slide. Consult an attorney, reference the ADEA rights, has to be easy to understand, etc. I want to pause on some tax because tax is so fascinating. So I don't know, about 20 years ago, almost exactly 20 years ago, we got IRC section 409A, which everybody now knows about in a context of stock options. That's the rule that requires stock options to be priced at fair market value. Well, there's another application and a broader application. It requires any deferred compensation, meaning if you earn money in 1 year and get paid in a later year, that's deferred comp, has to comply with this statute. It requires a written plan or agreement. And if you're going to defer that amount so that you don't get paid the same year or within 2.5 months after the same year that you earn it, then you have to make a deferral election before the start of the year in which the services are performed generally. And then it can only be paid later on a permissible event. For example, separation from service. So we've got a regulatory environment for deferred compensation now. That is Section 409A. The penalties are huge, right? First of all, employee gets taxed immediately, even though they don't get the money till a later year. Plus, they got to pay a penalty tax. Plus, there's a state penalty tax in California, plus interest on the underpaid taxes. So it could be a big number. It applies generally to employees, but can cover some independent contractors if they're sufficiently employee-like enough. No accelerated payments, no additional deferrals or modifications. These rules are so cookbook. They are so highly technical that you really do need an accountant or a lawyer or professional to work your way through them. So much so that I rarely see a deferred compensation plan anymore. Instead, what we do is what I've highlighted. We draft anything we're doing to basically fall outside of these rules altogether as what we call a short-term deferral. In other words, no matter what it is, if we're going to defer, we're still going to pay you no matter what within 2.5 months after the end of the year in which the amount's earned. Now, I know what you're thinking. Well, how about we do this? How about, I'm a founder and a company needs the money, so I'm just going to defer that money and you just pay me when the company gets financed. And I know different lawyers have said different things about this, but I don't think that works. One theory is, well, that amount isn't vested until the financing occurs, and therefore it's not a deferral at all. But I don't think so. I think I think it is a deferral, and that we have to put and the financing is not one of my events that allows you to defer. Oh, where is it? It's not one of these permissible payment events. So I think you are within 409A. And if you're going to do that, you need to put that in the context of a plan that complies with 409A, or that amount has to be paid in no later than 2.5 months after the year in which it's earned. Okay, I want to say a few words. We're going to go a little over time, it looks like, but I want to get through a couple things. Equity compensation. So you're a startup, you got lots of equity, you don't have lots of cash. Aside from minimum wage, et cetera, you are going to compensate people in equity. How are you going to do that? Restricted stock, stock options, phantom stock, or RSUs. Let's go through them. Typical offer letter will tell the employee, look, we're going to give you some equity along with your cash comp. And we're an early stage startup. We don't have a stock option plan yet. So I'll tell you, or a stock plan. But so number one, we're either going to just grant you the right to buy stock today, or we're going to give you an option to buy stock later. And that's how we typically do it. And then when a company does get a stock option plan, at that point, it grants the option. And the thinking is that, the stock option plan will be put in place when a company gets financed, right? If it doesn't get financed and won't get a stock option plan, employee won't get the option, but there's nothing there to fight over anyway. It just doesn't matter. And if it does get financed, at that point, there is some value. And at that point, the employee gets a stock option or equity grant. So that's why we usually just, toss all this stuff in a very simple, straightforward offer letter and defer the actual equity grant until later when we know the company's going to go. Now, here are the ways that gets granted. One, restricted stock. That is actual stock ownership. The employee has to pay for that stock in cash, property, or services. If they pay for it in services, they're going to be taxable as compensation on the value of stock. If they pay for it in property, they might be. And go back to their very first session to know when there's exceptions to that rule of taxing stock received in exchange for property. And then now we've got a sale of a security, and a lot of people forget about this, but that has to be, exempt and qualified, or registered and qualified under state laws, or permitted. And so sometimes, every once in a great while, we're just not even able to give restricted stock to somebody because we just don't have the state securities law exemption. Usually we can easily get around that here in California by using what we call a 25-102O exemption for employees, but that requires a plan. So go back to previous slides, see my offer letter. However, that's one way that equity gets put in the hands of the employee, just an actual grant of stock. Second, and more commonly, grant of an option. We went over this last month, but basically an option is a right to buy stock at fair market value exercise price. Again, we grant that option. There's no tax on grant of the option. There might be on exercise of the option. And we have an automatic federal Rule 701 securities exemption for that issuance. And we also have a state securities exemption, although in California, it does require a filing. We talked about this last month, so I want to talk about option grants. Restricted stock units is something you might have heard about. An RSU is simply a right to stock. Okay, it says if on this certain date, if you're still employed here, we're going to issue stock to you. And it's going to be issued on these vesting dates. The problem with that is that that's a taxable event. You have compensation equal to the value of the stock on issuance. So on each vesting date on which stock is issued, the employee has compensation income, but no cash. And that's why you almost never see RSUs in private companies, startups. You see them in public companies, so the employee can go out into the market, sell the stock, or whatever, so they can pay the tax. Phantom units I use quite a bit, especially since 409A came into enactment. And a phantom unit is basically just a right to economic rights that mimic stock ownership. Doesn't have voting, doesn't have inspection, doesn't have any other rights. It's as if that person owns stock. And we have to comply with we either comply with or structure to avoid all the other rules that I've talked about. But beyond that, we can have vesting provisions, we can have acceleration, etc. Usually a phantom unit, the unit holder has to be employed by the company when a company exits in order to participate in the proceeds of sale. If we want to do anything other than that, then we have 409A issues, and we have to comply with all the rules of 409A, which, like I say, we typically try to just avoid it. And then there are other bonus plans. You should just be aware when you hear the term ESOP, I know people have come to identify that with a stock ownership plan, with a stock option plan, but it's an entirely different animal. And that's a whole hour in itself. I used to draft ESOPs. Trust me, it's much different. It's basically a qualified plan like a profit sharing plan or a 401k where employer stock is used instead of cash. So there are other incentives. Not often that startups will use these. They're typically just leveraging their equity early on. And finally, I'm not going to spend much time on this, but I don't have a special session on immigration, at least not yet. I do have entire podcasts on this topic that you're going to want to listen to if you're concerned about this. I gather there's probably a lot of people in the audience that know more about this than I do, because you've probably been through the process. But for my purposes, I just want to mention that people often ask, gee, I'm here on a B visa. And I've started a company. Can I start a company on a B visa? And the answer usually is, well, yes, but you just can't be employed by it, so it can't pay you. And then we have the most common visa category I see is H-1B. Somebody is working here in the U.S. for a U.S. employer, and and then they want to start their company and move to a new company. And it's not as easy as you might think, but it is doable, where the new company eventually can be a real company that can employ them. So with that, I'm sorry, I don't have time for questions. We're a little over time. My information is in the chat and on my slides, which I will be sending to you. And let me drop it into the chat one last time. And you'll be getting an email from me with if you'd like the slides, I'll send them to you as well as a link to the recording. And with that, we do this every month. This was Roger Royce Haynes Boone on employment law. And at that point, I'm going to stop the recording.